Good morning, everyone, and thank you so much for joining us today. We're delighted that so many of you have signed up for this session in relation to public procurement disputes, looking at challenges under the Procurement Act in the new regime. So a little bit of housekeeping to start off. Firstly, there will be a fire alarm test at 9:30, so don't panic if you can hear it on the recording. It is scheduled and it should cease relatively quickly. Next slide, please, Lisa. Your speakers this morning are myself. I'm Ailsa Anderson. I'm based in Manchester. I'm a legal director in Irwin Mitchell's disputes resolution team, and I'm delighted to be joined by Aidan Ray, barrister from King's Chambers, who specialises in disputes of this nature. Next slide, please, Lisa. There is a posting link for feedback that will be available throughout the recording, and we'll share it again at the end. But as ever, we do welcome any feedback that you've got about the session. It is always really useful and informs our approach to future sessions. Now, a point to flag is that I know that we've already had a number of questions submitted, which is great. We'll seek to address those at the end of the session, as well as any other questions that you might have. Do feel free to pop them into the question and answer section. If we run out of time, we can always circle back and respond to individual queries after the session. And finally, just to make you aware that the session is going to be recorded, and we will circulate a copy of the recording together with the slides to those of you that have attended in a follow-up email after the event. So what are we going to be covering across today? Firstly, you're going to get an overview of the statutory reform and the complex regulatory framework that's applicable to public contract procurement matters. We'll provide a summary at a very high level of who and which contracts the laws apply to, an overview of the duties imposed by the Act, a summary of the available remedies, and some key features of the Act relevant to disputes, highlighting areas of difference between the new regime and the previous one in terms of challenges. And then Aidan will go into a more detailed review of interim remedies under the Act, followed by questions, time permitting. Next slide, please, Lisa. So with 385 billion or thereabouts spent in relation to public contract procurements per year, 1 in every £3 of public money is spent on it annually. Suffice it to say that this is an area of extreme importance from a public policy perspective, and the regulatory framework is intended to ensure that contract award processes are fair, transparent, and maximize social value. Next slide, please, Lisa. So how was public procurement regulated before the Act? In the UK, the public contract procurement processes were previously governed by several key pieces of secondary legislation, and there's links to those in this slide, should you wish to revisit them. Together, these were known as the regulations. Next slide, please, Lisa. But what is public procurement law now? Procurement law regulates the process for awarding contracts for goods, works, and services by public sector entities and specific utility sector organisations. Previously, the regulations applied to specific types of agreements and contracts, and the Procurement Act came into effect on the 24th of February. All relevant procurements commencing on or after that date are governed by the Act, and procurements starting before that date are governed by the previous regime under the regulations. Next slide, please, Lisa. So which contracts do public procurement laws apply to? They apply to contracts awarded by contracting authorities, many of whom I know are joining this session, including government departments, local authorities, NHS trusts, and police authorities. The Act applies to contracts with an estimated value of not less than the threshold amount for the type of contract, and new threshold amounts have been introduced this month on the 1st of January by the Procurement Act 2003 Threshold Amounts Amendments. Now, often the applicable threshold will be at a level of about 5.193 million, though some are as low as 135,000 inclusive of VAT. Other provisions do apply, and you should be aware that they do in relation to certain below threshold contracts. And the laws cover entities in sectors such as utilities, energy, transport, construction, and postal services. Next slide, please, Lisa. So what was the intention behind the Act? I think predominantly to streamline the processes and bring together the various different strands of regulations into one cohesive document. It requires contracting authorities to have regard to the importance of value for money, public benefit, sharing information, and them acting and being seen to act with integrity. They must also treat suppliers fairly and look at reducing and removing barriers for SMEs. Contracting authorities must have regard to these objectives, which are set out in Section 12 of the Act, throughout the life cycle of the relevant procurement and once the contract has been entered into. Next slide, please, Lisa. So, in terms of the statutory duties, contracting authorities have to comply with the specified areas set out in the Act. They're enforceable by UK suppliers and also by suppliers from treaty states. And proceedings can be brought by suppliers who suffer or risk suffering loss and damage due to breach of certain duties pursuant to Section 100 of the Act. Otherwise, they may potentially be able to seek redress by a process known as judicial review. Now, there are certain exclusions that apply from the right to bring a claim, which include, for example, duties to have regard to barriers facing SMEs, which is the subject of a new bill that's passing its way through Parliament as we speak, duties related to procurement policy statements, and decisions on the debarment list, which have their own appeals process. Next slide, please, Lisa. So what are the key features of the Act compared to the position under the regulations? Well, standstill, which is a mandatory period following the notice of award, during which the contracting authority is not permitted to enter into the contract. Automatic suspension of contract making, which is suspension of the contract being entered into or varied on the issue of a claim. There's certain practicalities and dynamics around serving claims, which lawyers will be able to advise you upon, and the procedures and considerations for claimants have varied slightly in that respect. And remedies, both pre-contractual damages and the setting aside of contracts. Time limits for bringing claims and seeking interim relief also have specific deadlines, and those must be borne in mind at all material times in terms of initiating any challenges. Next slide, please, Lisa. So standstill. This occurs after the award of the contract, but before formal entry into it. It allows an unsuccessful bidder to request information and challenge the decision of a contracting authority. Previously, under the regulations, the length of the standstill period varied dependent on how the award decision notices were sent, but generally the standstill ended at midnight on the 10th day after the last notice was issued. Under the Act, the mandatory standstill period has been simplified and is now 8 working days. Next slide, please, Lisa. In terms of the automatic suspension, issuing a claim before expiry of the standstill and notifying the contracting authority of the claim suspends contract making and variation. It's the immediate effect of a legal challenge once that's been notified to the authority. The position under the regulations led to the court often lifting suspensions, deeming damages to be an adequate remedy. There appeared to be a very clear judicial tendency to favour financial compensation versus a long-term pause of the award. Aidan's going to talk in quite a bit of detail about the standstill and the scope of the changes to the suspension test in the second half of this morning's webinar, so I'll leave that in his capable hands. Next slide, please, Lisa. Remedies. Now, the key distinctions between these relate to the time at which a challenge is made. So if a challenge is brought pre-contract entry, the remedies include an order setting aside a decision, for example, the award decision itself or a particular action, an order requiring the contracting authority to take any action, for example, to reinstate a supplier or repeat the evaluation, an order for the award of damages, and any other order that the court considers appropriate. So there's a wide degree of judicial discretion. In terms of post-contractual remedies, where the court satisfied that the contracting authority has breached the Act and the contract has already been entered into, it must, in very limited specific set-aside conditions are met, and there's no overriding public interest reason not to, make an order to set aside the contract. It may, in any case, also award damages, usually and primarily for loss of net profit, though in some cases damage is calculated by reference to the loss of chance to make such profits. Next slide, please, Lisa. So just a little bit more detail about set-aside orders, because I know they're a source of material concern to contracting authorities. The Act retains the power to declare unlawfully awarded contracts ineffective, now referred to as set-aside orders. Now, this could apply if, for example, a required contract award notice has not been published, so that must be done. The contract was entered or modified before the end of the standstill period, and obviously it goes without saying that the standstill period should be revered. The contract was entered into or modified during an automatic suspension or in breach of a court order. Again, it appears to be a matter of logic that a contracting authority wouldn't do this, but that's not necessarily always the case. And in specified circumstances, the breach became apparent only after the contract was entered or modified. Now, these conditions seek to ensure that claimants have a fair opportunity to seek remedies, but there's still judicial discretion, and the court is bound to place weight upon public interest in relation to health or defence-related contracts, as you would reasonably expect. Next slide, please. So time limits, and this is the real pressure point in relation to disputes of this nature. For most claims in this area, the claim must be commenced within 30 days, beginning with the day on which the supplier first knew or ought to have known about the circumstances giving rise to the claim, though the court can extend this. This short limitation period ensures that disputes can be resolved swiftly, upholding the principles of effectiveness. And the position does remain broadly the same under the Act. But from a supplier perspective, it is critical to remain alive to the fact that the time starts running from the first time you knew or ought to have known about the circumstances, which may well be significantly before an award notice is issued, if, for example, there's issues in relation to the proposed approach to the evaluation or contents of a tender. Next slide, please, Lisa. So in terms of risk management for suppliers, limitation, it's 30 days as opposed to 6 years, which is normally the period that you'd be looking at if it was a contractual or a tortious dispute. Limitation can expire in relation to certain challenges well before any award notice and across the lifetime of the procurement or well after award. Suppliers should reach out to legal advisors at an early stage if they have any concerns at all about the way a procurement is being managed by a contracting authority. We can work with suppliers and authorities to seek to regularise the position when something goes wrong, seeking to avoid the need for costly proceedings where possible, and to achieve a fair outcome. Where proceedings are necessary or are issued by a supplier, we can help you to understand your options and to move quickly to comply with the relevant deadlines as necessary. Next slide, please, Lisa. And I'm going to pass now to Aidan.
Thanks, Ailsa. So I'm going to be talking about interim remedies under the new regime. And the question I've posed here is, the new regime, is it really just the same as the old regime? Next slide, please, Lisa. The jumping off point for considering the interim remedies, I think, is the assessment summary. So this is likely to be the trigger for considering things in most cases, and this is a new stage. An assessment summary is required to be issued pursuant to Section 50, subsection 3 of the Procurement Act 2023, before a contract award notice is issued under Section 50, subsection 1. And there are various things that must be included within the assessment summary. There's quite a long list of them within Regulation 31.2 of the Procurement Regulations 2024. The most important bit of information that I think you're likely to receive in the assessment summary is information concerning how the most advantageous tender was assessed against the award criteria and how the recipient of the assessment summary's tender was assessed. That's likely to be the trigger in a lot of cases. Not in all cases. There will be cases, as Ailsa touched upon, where you are aware of problems before you get there, but often this is likely to be the trigger that will crystallise that a tender hasn't been successful and will give an indication of the reasons why. Now, it is important to be aware that if your knowledge of problems in the procurement process arises earlier, the limitation period may well have started to have run earlier. So this will not always be the trigger, but it's a useful starting point for considering it, because in a large number of cases, this is going to be the point at which you go, something's gone wrong here, and we need to be doing something about this as a supplier. Next slide, please, Lisa. The assessment summary is then going to be followed by the publication of what's now called the contract award notice under section 50 subsection 1. And there are various requirements for the content of the contract award notices. And they're fairly lengthy, as I set out. They run from regulation 27.2a to 27.2w, so nearly but not quite the entirety of the alphabet. Probably, though, the most important detail that you're going to be looking for within a contract award notice, and if you're a supplier, if you're a public authority, the detail that you're going to want to make sure you get right at this stage in particular is the end date of any standstill period. Certainly for the purposes of interim remedies, this is a critical point. Next slide, please, Lisa. The reason for it is that under section 51, as Elsa highlighted, we have a new standstill period of 8 working days from the publication of the contract award notice. Now, this makes things slightly easier because under the old regime, firstly, there were variable times. It was often it was 10, sometimes it was 15 days, and it was days rather than working days. And so then, although all these things were resolvable, you could go through it and work out what happens if you end up, your deadline expires on a Sunday. It wasn't ideal. So the reference to working days at least clarifies things somewhat. The effect of the standstill is that during the period, the contracting authority may not enter into the contract, the public contract that it's looking at entering into, or the modification that it's looking at entering into. Now, there are various accepted contracts where this doesn't apply. Those are contracts awarded directly due to extreme and unavoidable urgency, contracts awarded directly to protect life, contracts awarded directly by a private utility, contracts awarded under a framework, contracts awarded by reference to a dynamic market, and light touch contracts. That list, I think, also gives you quite a good sense of the variability within the public procurement regime. So whilst the idea has been to streamline the regime with the new legislation, bring it all together, introduce greater clarity, the reality is that, and this is unavoidable because of the breadth of spending and topics covered by public spending, that there are different situations, different mechanisms for awarding contracts. And so you always have to be alive to that. Next slide, please, Lisa. The effect of the standstill and the importance of the standstill period really is beyond the fact that it stops the contracting authority from taking that step of entering into the contract. It's also important because if a challenge is brought and notified during that period, there is under section 101 of the Act an automatic suspension, provided that the claim is issued within the standstill period and the contracting authority is notified of that fact during the standstill period. Now, this differs from what happened under the old regime, where there would be an automatic suspension if proceedings were commenced before the contract was entered into. So it didn't matter whether you were in a standstill period or not, as long as the contract hadn't actually at that point been entered into. The effect of the automatic suspension is that it prevents the contracting authority from entering into or modifying a public contract or a convertible contract, which, just to add some further complexity, is another layer, which is where you have a contract which, because of something that's going to happen now, would become a public contract where it wasn't previously a public contract. Now, it's not fatal to your interim relief if you miss the deadline. You can still make an application to try and put in place a suspension if the contract hasn't yet been entered into. But this is a proactive step. It's something a supplier has to do rather than something which is automatically triggered by the litigation. Next slide, please, Lisa. Once you have that suspension, perhaps from a lawyer's point of view, the most interesting change that comes about in this area under the new Act is what happens when somebody then applies, a contracting authority applies, to lift the suspension. And what we are told in the guidance that's been put out by the government is that there seems to be an implication that the automatic suspension now is intended to be harder to have lifted under the new regime than it was under the old regime. And the way in which they've done this is that the new test brings into place front and centre a first consideration of the public interest in upholding the principle that public contracts should be awarded and modified in accordance with the law. Next slide, please, Lisa. Now, this test is different on its face, at the very least, because previously the applicable test was the same test that's applied across the law for injunctions. So it's the test that's found in American Cyanamid and Ethicon, and that's a three-stage test. The first thing is the court asks, is there a serious issue to be tried? The second thing, assuming that you get over the threshold test of yes, there is some sort of coherent claim there, is are damages an adequate remedy? And that traditionally is looked at from both sides. The court asks itself, firstly, the applicant for an injunction, or in the context of somebody in a challenger to a public procurement exercise, a claimant to a public procurement exercise who's trying to resist the lifting of the suspension, you ask, could they be adequately compensated in damages? And if they could be, that was effectively then a barrier to moving on. That effectively ruled out the possibility of an injunction, because if you could be compensated for in monetary terms, then the court said, well, you don't need injunctive relief for the most part. You also look at it from the point of view of the respondent to an application from an injunction. So you ask, could they be adequately compensated for in the context of the cross undertaking that you would usually get in damages? Once the court had asked that question, it would then go on to look at what's referred to as the balance of convenience, which is essentially a weighing exercise of saying, well, having identified that damages may not be an adequate remedy for the claimant, what are all the other considerations? How do they come into play? The issue that this raised in the context of public procurement is that damages would often be an adequate remedy, because if you're a claimant who's tendered for a significant public contract, you tend not to do that without some sort of idea of how much money you think you'll make from that contract. And so you tend to be able to say, well, there are uncertainties, but fundamentally the purpose of doing this was a commercial exercise. We intended to make money, and that's what we're looking at. And with appropriate expert evidence, actually we'll be able to put a figure on it. And that was problematic for maintaining the automatic suspension. So when you look through the cases under the old regime in which suspensions were maintained, that was usually only likely if there was some wider knock-on effect. So, for example, in the NATS Services Limited and Gatwick Airport Limited case, the concern was the reputational damage. If air traffic control services went somewhere else, the very fact that that had happened would have, it was said, such, or potentially would have such a severe reputational impact upon the claimant NATS that was a scale of damage that couldn't be properly or easily assessed simply by reference to a monetary award. Another example is encountered for CIC and Sunderland. What you had there was, if the contract was awarded, you were going to end up seeing a TUPE transfer of staff. You would see the loss of expert staff from the claimant. And effectively, that would hollow out the claimant's capacity to provide its services or tender for future contracts. It would destroy the claimant's business overall. So it wasn't just about this one contract, it was the effect that it would have on its ability to move forward, so that the losses went beyond, or the impact went beyond simply the loss of the net profit on that individual contract. So you're looking for those sorts, traditionally you were looking for those sorts of additional factors. Next slide, please, Lisa. Now, this is the new statutory test under section 102, subsection 2. As I said earlier, the first thing is the court must have regard to the public interest in, among other things, so it's not exclusive, these are not the exclusive public interest, but these are two primary listed, or specified public interests, upholding the principle that public contracts should be awarded and contracts should be modified in accordance with the law, and avoiding delay in the supply of goods, services, or works provided for in the contract or modification, for example, in respect of defence or security interests or the continuing provision of public services. B, the interests of suppliers, including whether damages are an adequate remedy for the claimant, and C, any other matters the court considers appropriate. Next slide, please, Lisa. So, on its face, this is a different test because it's placing compliance with the law at the starting point. And this means that jumping off point for the reasoning is more favourable, I think, than it previously was for challengers to the awards of public contracts, so those who are trying to maintain the automatic suspension. And if you read the commentary on the new Act, that very much seems to be what everybody has understood the intention to have been. But always with these things, there's a but. And the but here is there is no specified hierarchy within the statute. Just because one consideration comes before the other, so it is the public interest comes as A, and it lists two things that you have to bear in mind. That doesn't say that they have primary importance. And the first public interest, upholding the law, is immediately countered to some extent by the second public interest, where it's engaged at the very least. So where there is a continuing supply issue, for example, it's immediately recognised that that comes into conflict with the first principle, which is that you uphold the procurement regime. The other issue that I see with this is that actually a lot of these sorts of things are baked in. So to a procurement challenge is always involving somebody saying that the regime hasn't been complied with. That is the irreducible core of a public procurement piece of litigation. So it's always going to be that. Similarly, litigation over that issue is always going to delay the entry into a contract, and it is likely, therefore, though not invariable, but it is likely that it will ultimately also end up delaying the commencement of whatever was to happen under the contract. So those things are often going to be there. And once you move past those considerations, because you go, well, as a judge, right, I've identified this public interest and I've identified that public interest, you move on to paragraphs B and C of subsection 2 of section 102. And you're straight back into then the interests of suppliers, in which the adequacy of damages is specifically referenced, and you're back into other matters. And what is the judge supposed to do other than weigh these things? Well, the answer is that they're not supposed to do anything else. The power that is granted to the judge in this scenario is a discretionary power. Court exercises its discretion. And in doing so, you exercise the discretion by weighing different factors, weighing different considerations. So what is all of this if not the balance of convenience when you get to all the other factors by another name? Next slide, please, Lisa. So is this just actually the same as the old regime? Well, no, I can clearly see that there are certain obvious differences. The two most obvious differences are that the automatic suspensions will arise more rarely because of the need to commence and notify proceedings within the standstill period, and the introduction of the statutory test for interim remedies, including the lifting of a standstill, suspension rather. However, the new regime for interim remedies isn't that different to the old, because even if there is no automatic suspension, you will still be able to seek a suspension by interim order. And the new legal test for that, which looks so different on paper, might well not look so different in practice. I'll just let the fire alarm finish here. So you come back to this same point, which is the court needs to exercise a discretion and it needs to weigh factors. And we see this time and time again, actually, in the law where we have reforms, which is that judges don't often move quickly from what they already know. So where you are in front of a judge in the TCC, and that judge is used to and has spent their practice dealing with injunctions and applying American cyanamide, when they come to apply the new test, I think it's highly likely that they will understand the concepts that are in the new test by reference to what they knew well in the old test. They will also, however, be conscious, I think, of the intention, but parliamentary intention really is only supposed to be gleaned from what the statute actually says, unless there's ambiguity. I think we will see a change of emphasis. I think the new emphasis on public interest is likely to shift the dial in favour of the challenger to the award of the contract to some extent, but I think it is going to be limited. Next slide, please, Lisa.
Thanks, Hayden. That was really interesting. So, I mean, the key takeaways that we'd like you to bear in mind from today is obviously that Owen Mitchell has specialist dispute resolution teams that deal with public contract procurement disputes, and we can help in the event that issues arise in regard to them. We act in litigated matters and also in an advisory role, often in the background, helping people as and when issues arrive, and working with expert counsel such as Aidan to get great results when these issues do come up from time to time. What I'd be very keen for you and your teams to bear in mind is the importance of the standstill, and that limitation is only 30 days, which can be particularly helpful to contracting authorities and can be a source of real issues for suppliers. And so if you can cascade that information to your team, that would be very, very helpful. Now, I think we've got time to cover off some of the questions, which is great. I'll just have a little look at what's come in. And we've got a couple of pre-submitted questions as well. Now, where the questions relate to very specific facts and circumstances, we don't propose to deal with them on this call for reasons of confidentiality, but I'll follow up direct after this in that regard. I think we have hopefully dealt with the key issues in relation to the difference between the old regime and the new regime for the purposes of challenges. So that was another question that someone had kindly pre-submitted. And then there was a query about some practical examples.
Yes, and the problem with that, I'd said to Elsa, I'll come along and I'll talk about the recent, when I first said I'll come and talk with you, I said I'll come and talk about whatever new cases there have been, because I was updating a chapter in a book I helped to edit, which deals with interim injunctions and interim remedies in the context of public procurement. Is one of the things I deal with. And I thought I'd come along and talk about whatever new cases I'd found to update my book in. And when I got back in touch with Elsa, I said, the bad news is there aren't any. It's not entirely surprising that we've not got any new judgments yet, because the old regime still applies to quite a lot of procurement processes that will probably still be ongoing. And it will also be the one that's in issue in disputes which have already arisen. So we don't yet have any reported cases on the new regime, and we don't have anybody yet on the debarment list either. I checked that last night to make sure nobody had been added of late. So we haven't seen how that will work yet in practice, which means that I said, well, I'll come along and I'll talk about what I think about the new test, because actually, whilst it might not be worth an awful lot, it's all we've really got until we get some judgments. As lawyers, all we can really do is say, well, we've got this new act, this is what it says. Until the court tells us what it means, the best we can go on is, well, what do we think this means, and how do we think it will impact things? So at the moment, we're still waiting for the first challenges under the new act to come through, for people to be debarred. I think it's going to be interesting to see how the new debarment regime works, actually, as that's coming in, because one of the questions that we had was, what are the main differences? And one of the main differences is the widening of the scope for debarment. That's obviously a response to quite a lot of what we've seen in the press over the last decade about different situations where the press particularly picks up on companies being awarded contracts following previous high-profile failures or misconduct. And so you've got a widening of the scope of things that can be taken into account for debarment. It'll be interesting to see how that plays out and the challenges that come from that, I think, going forward. I see one of the questions we've got there is how useful is the the 2023 Act, the Procurement Act 2023, to defence-related contracts? Well, the answer is, I can't quite see what the second half of the question. That the answer is that in terms of utility, I'm not sure quite how I would deal with that. One of the interesting things about it is that whereas you had a separate regime, a separate set of regulations under the old regime for defence-related contracts primarily, it's now all brought within scope. But one of the consequences of that is, as I talked about earlier, you've got all these different types of you've got a unitary regime, but then within it, actually, you've got all sorts of different contracts. And so there are lots of different exceptions or considerations that apply in the defence field, defence sector, which won't apply in other sectors. And those are flagged up quite a lot in the primary legislation. So whilst you will see things saying, well, we've got a single unitary regime, if, for example, you are heavily involved in defence sector contracts, the reality is that there are specific things there that are going to apply. In particular, questions of urgency and sensitivity around information are two obvious issues, and continuation of supply in that field is also something that both the government and I think probably the courts as well are particularly alert to. Defence procurement is something which is very high profile, is the reality, and so there is a greater awareness of the impact there, I think.
And I can see that we've got a question in relation to the new thresholds that have been implemented as of the 1st of this month now. I don't propose to go through each and every one of them on this webinar, but I have published an article about that recently. So what I'll do is ensure that a copy of that article is circulated with the recording of this event. So hopefully that'll get to the bottom of any specific queries that you've got in relation to that. But yeah, we'll share that article with you after this.
I think also one thing I would add on that is the thing about the thresholds is, and it comes back to that point I was making about, we've got to look at how exactly does this regime apply to any given contract. So it's quite difficult. It would be really nice if you could have, very clear, if it's this, if it's that, it's that. And to some extent, you could have that sort of almost flow chart of decision-making process, but it would be quite a long flow chart. And so I think actually there are certain, for those involved in this sector, at the coalface, as it were, there will be obvious contracts which fall within the procurement regime, and you will understand as you deal with it which ones those are. But for anything that is outside of your paradigm example, I'm not sure that there's ever going to be a substitute for ultimately going back to what are the thresholds? How does this apply? Is it a light touch contract? Is it not? And working through that. Trying to simply address them in the abstract is really difficult to say, oh, well, this is what you should think about. I'm always very wary about that, because I think that's how people can fall into error. And I think there's no real substitute for going back and saying, right, this is my particular contract that I'm not sure about, and actually then working through everything, because also the thresholds and things change. So what you knew about it 18 months ago may no longer be applicable. So you've always got to, unfortunately, be just keeping up, which means there's no substitute for the hard yards, unfortunately.
I think we've got a question in relation to the impact of the Act on challenges about material change to existing contracts.
I think that's to do, if I've understood the question correctly, I think that's to do with whether existing contracts will, the answer I think is no, because existing contracts will be governed by the pre-2023 Act procurement regime. And so the new Act is not going to, as I understand it, engage with those, but you would have to look quite closely, because at the particular circumstances, again, always this issue of in the abstract, these things can be quite different. You'd have to look quite closely at what you were dealing with in order to make sure that the particular factual circumstances you were dealing with didn't tip over, so that you were so that actually you were engaging in a new form of a new procurement exercise, essentially, that did get caught by the regime. Again, it's that issue of being alive to the nuance, and unfortunately the nuance requires specifics.
Mhm. Okay, I think
we've covered all the ones that we can cover there. Thank you very much for having me to speak. It's been a pleasure. I hope it's been helpful for people.
Yes, thank you all so much for joining us. It's a pleasure to deliver these, albeit virtually. If you do have any feedback, as I mentioned previously, do please provide it. We're ever so grateful, and we do take it into careful consideration when we're delivering further webinars. Next slide, please, Lisa. Obviously, you'll have received an invitation to this one, and it included information about the wider webinar series that we're running at the moment. We'd welcome you to attend. There's some really interesting stuff that's being covered in them. So do please have a look and see if there's anything that's going to be useful to you. If we have missed any questions, as I say, I'll have a look through and I can get in touch direct to follow up. But for now, thank you all very much for attending, and thanks to Aidan for co-presenting. And we look forward to seeing you all again soon. And if you do have any follow-up queries in relation to this, my contact details are on the front of the slides, and we'll be sharing those, as I've mentioned, with you after this session. Thank you again.